this afternoon's Councillor briefing. We're talking Resource Management Reform Program and an update for our Council. Thank you to the team for the work that you've put in so far and the pre-reading that we've been able to do, and look forward to your presentation today. Thank you.
Kia ora, thanks for that, Sam. So I'm Michelle Flay, here to talk to you about resource management reform and provide a bit of a snapshot of the lay of the land today. And I'm here with Jeff, who's the team leader of policy planning. So just as a bit of a caveat on the information that I'm about to present, so it is really just a snapshot. Reform is rolling along at pace, and as you'll be aware in the media, sort of every week we're hearing a little snippet of something new. So the intent here is just to follow on from a presentation that I delivered to this group in February, and just provide a wee bit of an update. And as we know, the devil will actually be in the detail, and there's quite a lot of the detail that's yet to be understood. And I just wanted to also say at this point that I think we should all just keep calm and carry on as well. So what's coming is coming, we'll just take it for what it is. So just as a bit of a status update, so the focus of this presentation is on phase 3 of the resource management reform, but just as a wee bit of an update on the government's work program as a whole, I just thought it would be useful to just provide a snapshot of where we're at with phase 2. So we've got the Freshwater and Other Matters Amendment Bill, which has now been enacted, and we've got the Resource Management Consenting and Other System Changes Amendment Bill. SDC submitted on that bill earlier on in the year, and the Environment Committee have considered those submissions and have come out with an amended version that's due to be go through its second reading. And we also have a package of national direction proposals which are currently out for public consultation. So just going back to the Consenting and Other System Changes Amendment Bill, you would have heard in the news last week around additional powers that the Minister for the Environment will have, and the ability to sort of override local plans. So just to clarify, this will only apply where your plan is inconsistent with the national direction. So if you're heading in the government's direction, and you're providing for growth, or you're in accordance with other national directions, there shouldn't be a reason for the Minister to come and exercise these powers. The reason this flared up last week was with respect to a plan change in Auckland, where Auckland notified a plan change that didn't take full advantage of the density that could be achieved in close proximity to major infrastructure or the train station. So sort of was the issue inflaming issue. So in terms of the national direction rescoped package, there are 4 packages that are currently out for public feedback. So we've got the infrastructure and development package and the primary sector package. We've also got freshwater changes to comment on. So with respect to the freshwater, later in the year there will be an opportunity to comment on an exposure draft. So any feedback that we provide at this time may be reflected in that. We've also got the Going for Housing Growth proposals. So the government sort of has stepped back a little bit in terms of including proposals that would have required plan changes. Those proposals are likely to be progressed as part of phase 3 of RMA reform or the replacement of the Resource Management Act. Package 4 is really about providing sort of some foundational comments in which the MFE people can go away and work through. Moving on to phase 3 of the government's reform. Just to simplify things, the phases are really just the phases of the government's work program. Phase 3 is really about the replacement of the RMA. The expert advisory group prepared a blueprint, and following that report, Cabinet have since gone away and created a traffic light system, basically, where they've decided to accept some of those proposals, accept them with amendment, or have decided against progressing some of the blueprint proposals. Advice from MFE staff is to look for the blueprint for the trajectory of what's coming, as that is providing the basis of which the legislation is being drafted. In terms of timing, and the timing of relevance for local authorities, towards the end of this year, 2 bills will be introduced to Parliament. They're expected to be enacted ahead of the next general election, and then in 2027 local authorities would begin preparing the plans. In terms of the structure of the new system and the components of most relevance to territorial authorities, the functions of TAs would sit under the Planning Act, and essentially the Selwyn District Plan would then become a chapter within the combined regional plan. You'll note that within the structure there is no regional policy statements. And some of the functions that are currently undertaken by TAs, such as in relation to significant natural areas, landscapes, that kind of thing, will actually sit under the Natural Environment Act. And so that's just a shifting of responsibilities there. Another thing to note here is the development nationally standardised zones will be mandatory, and council decisions will really just be focused on basically which zone goes where, as opposed to being able to influence the provisions that apply within a particular zone. So main changes for territorial authorities.
Sorry, Michelle, Sam's been called to take a urgent call, so we please do carry on and we'll just get to the end of the session.
Okay.
In case you wondered why the Mayor had to leave, I apologise.
I did wonder. Thanks.
There was nothing that you said. I'll look to Malcolm to do any chairing of questions.
Okay. So in terms of main changes for TAs, there will be additional obligations in developing the regional spatial plans. There will need to be really close coordination with other councils and aligning the regulatory plan development. For example, Selwyn District Council will be able to make decisions on its relevant chapter, but this will, because it's going through the combined regional plan, this will all need to be aligned with public consultation that's going on at the same time within the other TA jurisdictions. There will be a reduced role in policy and plan development for TAs because of these nationally standardised zones, national standards and limits. There are expected to be reduced consenting workloads and a reduced role for compliance and enforcement. So Cabinet have taken a decision that there's going to be a centralisation of compliance, monitoring and enforcement functions with a regional presence. So that will mean that CME functions that are currently undertaken within a territorial authority will probably no longer continue as they are right now. Again, the devil will be in the detail. And just with respect to media comments around scrapping regional councils or reforms initiating local government reform, as part of the March Cabinet paper, there was a recommendation in that paper that an invitation for the Minister of Local Government and the Minister of RMA Reform to report back to Cabinet before the end of 2025 on whether there is a need for local government reform. So that's the current situation with that. And just in terms of other implications and the recommended approach to transition. So something to note here is that existing plans will be deemed to be part of the combined plans under the Planning Act. So there will be a specified date which will enable the decision making and planning and consents and permits to begin under the new legislation as soon as possible. Without affecting access to natural justice. Now, this approach differs somewhat to that taken in the previous government's reform, where there was quite a lead-in time in the development of local plans. So under the previous reform, it was staged. So there'd be the primary legislation, the national planning framework was being developed, and then local plans would then flow from that. This is different in that existing district plans would be deemed and may have implications for how easy it is for a subsequent government to repeal this legislation easily if decisions have already been made under the new primary legislation. So that is all I have to deliver. And is there anything else you still want to know or any further questions?
Thank you so much, Michelle. This is one of the topics that will also form one of the CEO's KPIs around giving councillors regular updates with regards to the RMA reforms. And as you can see, it is quite a moving feast, and that provides, some challenges, and also ensuring that we can continue on with our business as usual as well. So we are certainly committed to coming and giving a minimum of quarterly updates. But obviously, if something else comes along that's of specific interest, or we think that you need to have more urgently, then we will bring that back. But otherwise, I'm going to open the floor to any questions, and I'll get Malcolm to chair this bit, if that's okay. And Elizabeth, over to you.
Thank you. So the combined district plans under the Planning Act, that's not something we do for anything else, is it? Is this quite new? How do you envision this looking and being facilitated, and what the effect on the council operationally would be by doing that?
Yeah, so there isn't anything equivalent that within the current system. So there will be
I don't think there's been any indication of how they will prescribe that councils go through that process of developing those plans. So whether there's going to be a standard approach or whether it's up to the regions to councils within one region to work together and set their own process. But yeah, there's not enough information at the moment to understand exactly what that looks like. I can only assume that there's an expectation that each council will bring forward their part of that plan.
Like there's no scope of the intent of it where it's to prevent reinventing the wheel and to share information or share resources or anything. There hasn't been a scope in that regards.
Not that I'm aware of.
Okay.
This is a completely new process.
Yeah.
And it's likely that it will need to occur quickly.
Great.
Yeah, so based on that, it's likely to be prescribed within the legislation that's expected towards the end of this year.
My other question is, so you're doing a draft submission for the national direction on the 23rd of July, so we considered the meeting. Does that mean that that submission will come to us in its draft form and we will be going through it before you submit that?
Yes.
Or when is it due to be submitted?
On the 27th of July?
Okay.
Yeah, the 27th of July I think is on a weekend, so it'll be before that. But we have an hour on that 23rd of July meeting, so there's a bit of time there.
Thank you. Megan.
Kia ora. Look, this is testing my understanding of it, so I could have it all wrong. And so this is a question, although I'm framing it as a bit of a statement. So I guess what I've heard and what I understand, we have regional policy statements already, and we have regional, plans already, and then we have district plans. And to me, this is just seems like a bit of a reshuffle. So you're still going to have your regional plan through the, what was it called, the natural built environment. Then your district plan's just going to be picked up, pop in, and put into a chapter of this new regional plan, but it's still a district plan, it's still land use based. So the functions of council, each council hasn't really changed. And it sounds like all that's being rid of is the policy statements, is that right? Or what have I missed?
No, so there is going to be a narrowing of scope of what the resource management system can control. So we know that there are going to be a reduction in activity statuses and who can participate in planning processes, and there will need to be an exercise done to make sure that what is included within that plan aligns with the primary legislation that it sits under. So existing plans have been prepared under the purpose of the RMA. That will differ. Mm-hmm. So there will need to be changes to the policies that sit under the new legislation. And in terms of the policy, the regional policy statements, so I think what they've said is that there will be some bits of regional policy statements that may need to go up in the hierarchy, and then there will be some bits that will need to go down. So yes, I guess there will be some kind of division of what already exists, but yeah.
Right, okay, so jurisdiction might not change, but it sounds to me the impact on us at Selwyn is that the district plan that we currently have will need, even if it's going to be picked up and put in to this new chapter, will look significantly different. And you're saying that the policies and objectives that we've agreed upon might have to widen or narrow in scope in response to the primary act?
Yes.
Yep, that makes sense to me. And then there's and I understand the activity status, that's really helpful, and I also understand that with those activity status, the intent is to make less people involved in the decision, therefore a lot more consented activity. Is that correct?
So there is going to be an expansion of permitted activities.
Yep.
And in terms of who gets to have a say, basically those that come to the nuisance will not be able to complain. And if your land is zoned or owned, you can basically expand or increase your activities, do what you like if it's in accordance with the zone that you're in. And unless you are directly affected or impacted by an activity, then you will not get to have a say. And probably also important to note here that there will also be a new planning tribunal established to deal with small-scale, issues between neighbours and or councils and land users.
No, that's really helpful. So those that come to the nuisance cannot complain. So basically, you're saying it's going to really broaden reverse sensitivity protections.
Yep.
Yeah. The other question I had was,
Sorry, can I just add
Yeah.
to that also that it's unclear about what this might mean for advocacy groups. So the likes of EDS or Forest and Bird, who have typically had quite a large role in litigation and sort of challenging environmental policies, may not get be able to have the same influence under that new, the parameters around who can be involved.
yeah, and look, the lens that I put that through is mana whenua. So
Yes.
mana whenua no longer have the same opportunities to be involved in the decisions that they once would have. And so I'd hope that if we're framing up a response, that we talk about having inclusivity of voice. Ultimately, I think the government's going to continue to follow through with their increase of private property protection, which does therefore mean less people having a say. But it's still important to say what's important for our district is to actually be inclusive and allow everyone to have a voice if we can. The part that you talked about, the SNAs are being picked up and put over into the Natural Environment Act, and so it won't be under the Planning Act. What about things like the SESMs? Does that, because some of them are kind of, if you think some of them are intended to protect environmental outcomes, whereas others are intended to protect, like, potentially whakapapa or knowledge. So where does that sit?
Without having the detail
don't know
of
yet.
the legislation, it would kind of appear to sit under the natural environment legislation. So the purpose or the underlying intent of the Planning Act basically is to enable development. Without seeing the detail, it's probably going to lean towards the Natural Environment Act.
And
But we don't know.
just as a collective overall, like my impression of all of this, that all of the new regime coming through is that previously we've talked about the purpose of the RMA is actually to protect and sustain the environment and people and the life capacity elements of, as an RMA commissioner, I should know the language, but I don't, but life capacity kind of elements of the natural environment. And it seems like we've gone with a complete shift. And if we're going with a complete shift, then surely that equals that we're going to have less environmental protections. So is your overall assessment that this current suite of changes is going to actually put at risk some of the strategies that we've adopted, like the One Water strategy?
It's hard to say without having the detail. However, it is very clear that there is to be a narrowing of scope of the resource management system and a strengthening or focusing on private property rights. So,
Yeah, no, that's really helpful, and I think that helps us determine maybe the direction of where our submission might head towards. Thank you.
Thank you, Megan. Very relevant points. Sophie.
Kia ora, thank you for coming. I was going to ask about our strategies as well, because we've got the One Water strategy and the biodiversity strategy, and if they sit in the natural environment space, but we don't really know how that's going to work. So that would be interesting because, yeah, anyway. I feel terrified for whoever has to put together a printed version of all of the district plans in that transitional phase, because they're all so huge. But they're all sort of e-plans, aren't they? These. Yeah.
Yeah, so central government have indicated that all of the plans will sit within an e-plan
Right.
and all be accessible within the one online platform.
Fair enough. This may not be relevant to TAs as opposed to regional council, but when it says no regional policy statements, does that include coastal policy? Or are we supposed to start putting coastal policy into our district plans, or that says natural environment plan, Natural Environment Act, but I don't know if there's no RPS for that. Do we know anything about how that's likely to work?
Yeah, your coastal plans sort of sit under the RPS, so they would form part of the sort of the combined regional plan as a sort of maybe potentially a coastal chapter or something similar.
Fair enough. Another question I had was around the people being directly affected. I suppose if that feels like something that's going to get decided by legal challenges, like how do you determine who is directly affected? Like if you've got something, so for instance, Lydia and I were doing a water race hearing recently, and there's things to do with at different stages along a water race, somebody can be kilometres away, but they're still directly affected by what somebody does upstream. But they're not, they're not the landowner, they're not even a neighbouring landowner. Do we have any idea how that sort of thing might be dealt with?
So there is some direction around the concept of the economic concept of managing externalities. So that's probably something to keep an eye on when the legislation does come out. But it's difficult to understand in the concept of private property rights, how that will impact those downstream. And also, as Megan mentioned, the intergenerational sort of aspect of resource management. So that's unclear.
Yeah, I was just thinking water races is a very here and now type thing in the context of that particular hearing, but then you've got the ginormous externality sink at the bottom of the catchment known as Te Waihora. Okay, and another question I had, last one I promise, trying to find it. So it mentions around new plan changes to be restricted in the period between the development of a spatial plan and combined plans. Does that mean we might catch a break from people trying to rezone some land in the meantime, or how?
I think those sorts of private plan changes might still be allowed, but again, I don't know if we've got that exact detail. It would obviously restrict council promoting a plan change, but I'm not sure if that's going to go as far as restricting a rezoning request.
Fair enough.
I can't see the government doing anything to hold up development. They're very strong on going for growth.
Fair enough. And if it was, so if somebody was thinking of, requesting a private plan change or a rezoning of some description, would that be using, I'm trying to think, because there's the current rules, is there anything around, are they likely to make it easier just because the government is so keen on housing growth? Is there any indication they're going to make it simpler rather than having to go through the whole commissioner getting $100,000 worth of reports, that sort of thing together?
Again, we haven't seen the detail of the plan making process or the plan change process. So
okay,
yeah,
I don't imagine it will get harder. And just in terms of the deeming of plans, and needing to undertake a sort of a weighting exercise and making sure the system is operating and there's been decisions being made as soon as practicable. I expect this will be quite clear, and I don't think it will hold up growth or private plan changes.
fair enough. I didn't think they were going to make it harder by any means. It was trying to figure out how much easier they're likely to make it. But okay. Thank you very much for your time,
sorry, I was
guys.
just going to say, I think Michelle included in her report about plan changes that were underway under the RMA could continue through in that process, and similarly
Yes,
resource
that is
consent
fair.
applications. So, yeah, unsure of anything that comes after that.
Fair enough. Thank you.
Unfortunately.
Yes, it would seem that there's a bevy of people in Wellington beavering away trying to put some legislation together and put some flesh around the bones. Lydia?
I'm just looking at a few of the packages around the RMA reform, and the primary sector one, I know that we sort of chatted offline about this. Some of that didn't apply to us, but I see like in there around the LUC3 and the implications that that might have for us as a district, considering we have an amount of class 1, 2 and 3. And so, yeah, I've got some concerns around the removal of LUC3 from planning as well. And I know a lot of this is probably crystal ball glazing for you guys, but I was looking at, so in the freshwater one around the mapping of drinking water, and you know, that would be a requirement for regional councils, but then we're seeing in the news to be rid of regional councils. So yeah, I guess I'm concerned, like in your slides you talk about the work for us, and so to me reading these packages, there seems to be a lot more work that is going to come to us, because effectively if there was no regional council we would be doing the mapping. Is that correct?
Yeah, so we don't know how these reforms will impact local government, the structure of local government at this stage.
Any more questions? Elizabeth, you have another one.
Thank you, Malcolm. So just looking at the range of existing RMA provisions and the 5 themes, so we've got systems improvements. I'm not sure if, or infrastructure and energy, for example. So we've got a lot of solar farms getting consented all over the country, but as we know, our Southbridge one hit a hurdle with having to go through the public. Now, the private property rights, would that come under, do you see that sort of thing, like consenting your whole farm for solar panels, being under that allowance for the private property use?
So we just need to be clear here that the packages are in relation to national direction prepared under the Resource Management Act. Mm-hmm. The property rights concept will be introduced through the phase 3. So the government have said that the national direction that is being prepared will fit in or be consistent with phase 3.
Yep.
But it's sort of unclear how that will play out. And with respect to solar panels, the government do have a focus on making consenting of renewable energies easier, faster.
So I guess I'm trying to sort of pad out whether you just think that it might be a case of that the public and you do say neighbours that are affected, but I guess something like that, people might say, well, there's no real effect from solar panels, so potentially we could see things like that come under that that umbrella of private property rights, and not require or not have, there's no opportunity for the neighbours in the community to feed into that decision making. That's what we're potentially predicting here.
Yeah, so with what you're talking about, the private property rights and what will apply within these nationally standardised zones, mm-hmm. So the community will get to have a say, and the council will have a say on which of those zones should apply where. So if there is sort of for example, a rural zone, and the consenting of sort of a solar farm is anticipated within that zone, then it's likely that there wouldn't be any involvement with neighbours. So yeah, it would depend on what the council considered to be an appropriate zoning at the point of developing the combined plan.
Okay. Tiny homes, would this potentially also then under private property we wouldn't really have a say if people wanted to park a tiny home on their property?
Again, it would just be dependent on whatever was anticipated within that zone. But the government have indicated that they're quite happy about tiny homes and have created more enabling regulations for those. So
I'll talk to you about that soon.
uh-oh.
Any more questions? No more questions? Well, as you've said at the very introduction, the devil will be in the detail. And as it will, it would seem that this is a very pro-development piece of legislation which may take away a lot of environmental protections that we have. We'll just have to wait and see what we've got. Thank you very much for your presentation. I have been looking forward to trying to figure out what's going to happen. And this is our last piece of work for the day, so we'll close the meeting. Uni here, te pou